And you want to move forward with your trial.
Yes.
And I do want to make sure, based on the indictment and your history, that you are a first-degree enhanced if you are found guilty, which means your minimum punishment would be 15 years. You understand? Okay, then I'll number the case. Mr. Lewis will get that number as soon as docket's over today.
Thank you.
Thank you, Judge. Are you Robert Eaglin?
Yes.
And this is 24 DCCR 2382. Mr. Eaglin's charged with aggravated assault with a family member, and this is set for trial to begin with jury selection next Monday. What is the announcement?
Well, Judge, we're ready for this.
Okay.
Being ready for trial. We did get a new offer from the state that included a reduction that would amount to a time served sentence for Mr. England, and the state would be willing to accept a no contest plea as well. And Mr. England, to my understanding, is rejecting that and still wants to go forward.
Judge, if I may, just for the court's knowledge, fill that in a little bit. Obviously, it's up to the court to accept that. The state would be willing to ask the court to consider a no contest based on the evidence in this case and proffer to the court evidence of the offense itself. This case was set for trial back several months ago. It was reset on part of the state. We are ready for trial. I have secured arrangements to have the complainant, Mr. Hernandez, here. I have offered Mr. Eaglin, based on the nature of the entirety of the case. If you'll recall, it was first indicted in CDC. We were unable to locate her. He was in custody for quite some time. She then surfaced. It was re-indicted. She has been cooperative all along the way. I just want Mr. Eaglin to know, from the state's perspective, this offer is not made based on lack of a witness, lack of having officers. My investigators have worked up the case already, and we've met with witnesses. We'll be ready to proceed. It is based on judicial economy, and out of fairness to him, I feel like the time that he served would be sufficient for the case as indicted with a no contest plea, and I want him to be fully apprised by the court, if you don't mind, before we go through all those hoops of bringing her here again, that he understands what it is that he's rejecting, and that I will intend to proceed, obviously, with the deadly weapon finding and the full indictment, which enhances his sentence.
So what is that new offer?
5 years credit for time served. However, that would be worded on the judgment. I believe he has it, Your Honor, or in alternative, a 10-year probated over 10-year probation, both of those to count one of the indictment.
So, Mr. Eaglin, you've heard all that, and I'm sure Mr. Lewis has talked to you about that. And it looks like, obviously, there was a much larger offer that you rejected some time ago. Today, I'll number the cases for trial. Your case is obviously one of my older ones. I'm not sure if it'll be number 1 or number 2, but it's going to be right up there, and probably going to trial next week. I want to make sure you understand what the offer is now, which would be either a 5-year term where you would get credit for any time that you've served, or a 10-year probation. You have every right, again, to reject that. We can go to trial next week. I do want to make sure you understand that after today, once I number those trials, I don't typically accept plea agreements unless there's something very different that comes up or there's some issues. Do you understand?
Yes.
And you want to move forward with your trial?
Yes.
And I do want to make sure, based on the indictment and your history, that you are a first-degree enhanced if you are found guilty, which means your minimum punishment would be 15 years. You understand? Okay, then I'll number the case. Mr. Lewis will get that number as soon as docket's over today.
Thank you.
Thank you, Judge. All right, so again, you're Brian McWade.
Yes, ma'am.
And get it pulled up again.
June 2nd. Right, June 2nd. How are you doing?
Now it's spinning.
I'll have 7 files.
Okay, so Mr. McQuaid, in cause number 26, DCCR 0402, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from March 8th of 2026. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Macon that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year 10-year term in prison that would be probated. You'd be on probation for 10 years. You would do 30 days upfront time and follow all of the rules and conditions of probation. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to enter a plea of guilty. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, we'll get it set for trial. Is there any reason, Mr. Coleman, to believe that offer would change?
No.
So I do want to make sure you understand, Mr. McWade, that once your case is on my trial docket, I don't accept this plea agreement again, unless there's some new information that the attorneys don't have or know about right now. Otherwise, if you change your mind and you want to enter a plea of guilty later, it would be either open to the court or to something other than what's been offered today. Do you understand?
Yes, ma'am.
All right, we'll get it set on the trial docket. Mr. Macon will begin preparation for trial.
Thank you.
Good morning, ma'am. Are you Sasha Swofford? Just stand right there. Are you Sasha Swofford? Answer yes or no, please.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. Swofford, in cause number 25, DCCR 1493, the state is elected to proceed on count 1 only. It alleges that you committed the state jail felony offense of theft of material, aluminum, copper, bronze, or brass, and that's from June 30th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Swofford is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of material, sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I handed you the trial court certification that shows that this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with Ms. Holmes. All right? Good luck to you, ma'am. You can go back with the bailiff. Good morning, sir. Are you Roger Anders? This is 25 DCCR 0388. Mr. Anders is charged with aggravated assault with a deadly weapon. And what is the announcement?
We're ready to go.
State's
Just
ready.
based on the trial document.
Okay.
State's ready, Judge. We'd ask that you call a name, please.
Today,
Yes, ma'am.
what is that name?
The Sudden Surprise. The Sudden Surprise Stevens, Judge.
The Sudden Surprise Stevens.
Very loud.
Ms. Stevens has been here with us before.
So I've been.
Okay.
It's not one of those you forget.
Yeah.
Judge, we'd also ask if she is here that you admonish her about the consequences. She's under subpoena. She's already been subpoenaed. But the consequences of not. We've also subpoenaed her to bring the 2 juvenile witnesses with her as well. Yes, Steve.
Miss
Good call.
it's her. It's opposite.
You come in.
Y'all, if you'll move around this way, please, sir.
Seven.
Good morning, ma'am.
Good morning.
You are LaSudden Stevens?
Yes, ma'am.
And Ms. Stevens, I just wanted to bring you here. You are under subpoena for a trial next week regarding Mr. Anders. And I just want to admonish you that once you are under subpoena, you are required by law to show up when you are told to show up. Also, if there are any juveniles that are part of this that are also under subpoena, that you are required to bring them here if they're in your care. Do you understand?
Yes, ma'am.
Okay. If you don't, then there could be potential consequences, and nobody wants that. I'm not trying to threaten you. I just want to make sure you understand the importance of it so that there's no issues with you getting any kind of trouble. Okay.
Yes, ma'am.
All right. You can step back out.
Thank you, Judge.
All right. And so looks like there was a previous plea rejection in this case of a 10-year term, correct?
Yes,
Yes, ma'am.
Any changes in that offer or negotiations that I need to be aware of?
No, Judge.
No.
All right. So I will number the case as soon as docket is over today. All right. You can go back with the bailiff. You're Hayden Burkhalter.
Yes, ma'am.
This is 2060 CCR 0324. And Mr. Burkhalter was previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. I received that pre-sentence report. Has everyone had an opportunity to review that report?
Have, Judge.
Yes, Your Honor, I have.
Any additions or corrections?
No.
Not from the state, Your Honor.
Nothing finished.
All right, Mr. Burkhalter, at this time, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, defer all proceedings, and place you on probation for 10 years. You are ordered to pay the $500 fine and to follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. If you do everything that you're supposed to on this probation, this is an excellent opportunity because you will not have a felony conviction on your record. And at the end of the probation, if you successfully complete it, the case is actually dismissed. You'll never have that conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court. You can be found guilty of the offense and sent to prison for anywhere in the range of punishment, which is between 2 years and up to 20 years. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. As soon as the probation will talk to you probably today, but as soon as you're released from ISF, first thing you do, go to probation, get everything started, okay? Good luck to you, sir. You go back to the bailiff.